all this, my lord, I will link up with my argument that the court ought to grant a degree for irretrievable breakdown because all the factors that are essential to a marriage have disappeared. They no longer exist. The only question is how to separate amicably. There is no other question for consideration. And of course, the other question for consideration is welfare, more particularly of the wife and the children. I'm in strong disagreement with judgments of this court, which seem to indicate, and I believe that the union has filed an affidavit, not in this court, but in the restitution matter, saying that marriage is a sacrament and it is the public policy of India that we don't break marriages. Well, it is the public policy of many countries in the world.
Two different things. Sacramental is how a marriage is made. Maybe contractual or sacramental. Whether marriage can break or not is not in doubt with the divorce provisions being there in all the things.
Fine.
Now, the issue is that under the Hindu Marriage Act, the divorce is, the whole thing is based on a fault theory. That if you have fault, you can't take advantage of that fault.
I understand. Section 23, subsection 1.
Irretrievable breakdown would have been a ground reality of the situation without getting into a blame theory.
Yes.
They look too good, and it's many cases we come before the court.
Yes.
Two where we have settled it, we have passed, sent to mediation, worked out a divorce. Two very good people may not be good partners. That's one of those things. Not necessary that sometimes we have come across cases where people have even lived together for a period of time. Then marriage breaks down. So being companion is different. Being married in the rigors of the marriage, how it works out are different systems.
Look, I understand that in order to answer this reference, one will have to get into the difference between fault theory of divorce and no fault theory of divorce, without any doubt. But my lord, it's not such a black and white issue. The way I'm going to present it is there is an overlap between the two. And you have never seen a petition in which only one person alleges something and the other does not. There is always that claim and counterclaim by two sides. Then the question comes, are you going to look at the fault theory? Because section 23, subsection 1A specifically says that no party can take advantage of its own wrong. And the fault theory in Indian law is smuggled in through section 23A. No person can take advantage of their own wrong. And sometimes your lordships have used the expression, people who come to court must come with clean hands. That's the limited role of the fault theory. The fault theory has no role beyond that. That's my submission, my lord.
Also, to my mind, very subjective. What is the fault? See, somebody may say there are allegations made. She does not get up in the morning and give my parents tea. Is it a fault theory? Or somebody, you could have done the making of the tea better, maybe. Then, so, a lot of them are arising from a social norm. Social norm where you think that the lady must do this or the gent must do this. And from there we attribute faults. So this is another concern I have, that what we attribute as fault is not really a fault, but it's an understanding of a social norm, how a particular thing ought to be done.
Changing social.
And
changing social norms is very important.
Very rapidly changing norm. Rapidly changing norm in terms of every couple of years this norm changes. That is the ground reality.
That is why this court has held that public policy is not frozen in time. Public policy, the West Bengal case, the West Bengal, I forget the exact cause title, but in the where the Henry VIII clause was challenged in this honorable court, which allowed for unilateral termination of a contract. And the question was, what is the constitutional validity of that unilateral termination law? There, the court has gone into the whole issue of public policy and held that public policy is not something static in point of time. Similarly, social norms are not static in point of time. Social norms change. It is no longer possible to argue a case of this kind or any matrimonial issue by relying on the laws of Manu. And about that, my lord, I'm very clear. And therefore, my lord, arguments such as it's a sacrament, and therefore we should not agree to this theory of irretrievable breakdown do not make any legal sense.
So that's 1956 on. Once you, it was sacrament, always treated as sacrament. 1956, we introduced a divorce. Once you introduce a divorce, that in a sacramental marriage, divorce can take place is known. Question is, in that divorce proceeding, should somebody must be attributed a fault, or if two people can't live together, they go for a consent divorce, which was also introduced after some
Yes.
stage of time. Now the
Yes.
third scenario is which, well, you may think the other person is at fault. He can't somehow sit face to face with you and spend time with you. So if the court comes to an opinion that this marriage is not capable of any reconciliation, then there's no point in a actually pointless marriage, which is, as you say, the fundamentals of marriage are absent. And the only other thing is that what terms the marriage should take. You take in, protection and protect the women in whatever way. Sometimes women are actually better off than the men, so they don't even. We've seen cases where they agree that as long as this. I've seen cases where normally the women resist. The man was resisting. I said, "What's your problem?" She doesn't want anything. She is has a better capacity to earn, a better position, but the man doesn't want to let go. I've accepted 142 even in those cases and granted this is being obvious unnecessary.
Yeah.
If people have not lived for a couple of years.
Yes.
It works now today both ways. Say right to resist.
Because the law,
Right to resist.
the law itself is general.
Yes.
It will work both ways.
Can we catch tomorrow?
Yes. And the
Your Lordship, please, your Lordship,